There we go. Thank you, Lindsay. My name is Olivia. I am the consultation attorney with Sanctuary for Families located at the Queens Family Justice Center. And this petition drafting clinic is a project that is primarily run by the consultation attorneys in multiple boroughs. So I am one person who you might be seeing when you are volunteering. The other person is Priscilla Hamilton, who I believe is here. Priscilla, if you just want to give a quick wave so that folks know your face. Here's Priscilla. Perfect. So Priscilla is in the Bronx, but as you hopefully are aware, this is an entirely virtual clinic, so you will not be expected to come to Queens or the Bronx for your volunteer duties. That's just where we do our work from. And then also joining us is my lovely supervisor, Lindsay Song. Lindsay's the associate director of the team here at the Queens Family Justice Center and is going to be available for any sorts of questions that pop up today. And you may also be encountering her during your volunteer times if things are on fire and we got to pull in more than just me. That happens on occasion. Hi. Okay, great. So let me just pull up the PowerPoint. I know how to do things like share screen because it's 2024. Okay, so welcome to Petition Drafting Clinic. We are the first of the clinics to be developed. There are a number that are in the works that over the next year or so you might see as additional volunteer opportunities. But for us and the current clinic that is available, we handle child support, spousal support, and paternity matters. So that is actually a large amount of the sorts of cases that folks come to the family court seeking help with. And it's also the sorts of cases that you don't have automatic attorney representation on. So for particularly the child and spousal support part, you may be the only attorney that these participants are working with. And so being able to give just basic advice about the process that they have ahead of them and helping to plan their next steps with them is a really crucial part of the clinic, in addition to the actual drafting work that you will be doing. So this is just an overview of what we're going to do, some introductions, things about the clinics, and then an overview of the actual substantive law and the drafting. There will be time for questions at the end, but please feel free to pop any questions that you have into the chat, and someone will alert me to the existence of questions, because I don't think I can see the chat at the same time. So just briefly, what is Sanctuary? We are a nonprofit organization. In fact, we believe we're the largest legal center in the country, if not the world, who is devoted to helping survivors of domestic violence, intimate partner violence, gender-based violence, all terms that you might see being used, and in both the legal and the clinical side of things. And so we have, like I said, legal, clinical. We also run a shelter. We have economic empowerment programs, and we provide folks with direct financial grants so that they can use that sort of money for whatever they know best that they need. We've got about 100 folks in the legal department, and so we have a wide variety of projects. Many of us are working on family law and matrimonial matters, but we also have teams devoted to immigration, anti-trafficking, public benefits, incarcerated survivors, and then you all are part of our lovely pro bono project. And in 2022 to 2023, over 67,000 hours were donated by folks just like you, and every single one of those hours is really deeply appreciated and makes a huge difference with our clients. So if after all this, you're like really into the Sanctuary vibe, there are plenty of opportunities for you to continue doing pro bono work with us. So one of the projects that we are part of is that we have staff members who work out of every family justice center in the city. So there's one in each of the 5 boroughs. And the idea is that it's a one-stop shop where you can find folks who can help you with the family law that you need, immigration matters, as well as criminal matters. So we have certain departments of the district attorney's office that are located within the family justice centers, and they can receive case management services to connect all of those sorts of cases that they have. Folks, it's often very overwhelming when they're trying to work across multiple court systems, especially when the cases are related. So we are able to provide a full range of legal services as well as the case management side of things. The purpose of the clinic, which was instituted when we came into the FJCs last summer, is that folks get a screening when they first arrive at the FJC, and they discuss with their case manager what their legal needs are, and then their case manager sets them up to speak with an attorney. However, a lot of people who then are speaking with a family law attorney need additional help. They need help drafting an initial petition or a motion, and we can't help every single person who needs that sort of assistance. And so the purpose of the clinic is to really funnel all of the folks who are requesting this type of service towards a team of attorneys, essentially, which will be you guys, who are able to help them draft a well-drafted petition and some other related documents we'll talk about later, because these petitions are the basis of their case. They are the foundation for the litigation that this participant is going to be expected to do. And like I said before, largely without further attorney assistance. And so having that strong petition and that strong understanding of the process can really make a huge difference in the lifespan of a case and in a participant's ability to smoothly navigate these really, complex and not instinctual systems of family court. So the logistics of the clinic itself. So like I said, first the client comes into one of the FJCs, receives their case manager and then their initial attorney screening from a sanctuary attorney generally. There are a few other partner organizations that also do screenings, but we're the primary, so we see the most folks. And then if the client, you will often refer to these folks as clients, even though we are not working with them in a formal attorney-client relationship, just as a heads up. If they need help with child spousal support or paternity, then that attorney who is doing the screening will assess for further eligibility for the clinic. And then if they consent, then the client will get scheduled in for one of the clinic dates. And then we gather up some information from them, the documents that they might have, and send that off to your firms attached to the specific clinic date that is the participant's actually going to be working on. And these are those clinic dates. So whichever firm you are connected to, everyone except for Paul Weiss this time around has 2 shots to do the clinic. So if you have already volunteered for one of these days, then that's fantastic. If you have not, then take a look, see which dates might work better for you than others. And you can speak with our pro bono directors and your coordinators and figure out how to get on that list. But these are the upcoming dates through December, and then we will be sending around the next chunk of dates essentially once those have been formalized. So what does the clinic day look like? You might be asking yourself, what am I actually going to be expected to do? So a key point is that by volunteering, you are agreeing to be available for the whole time period. And so that means from about 9:15 until 3 p.m. is when we generally anticipate that the things can be wrapped up. Truth be told, it's not uncommon for participants to need help beyond 3 p.m., but that is not expected of you. After that point, that is when myself or Priscilla would step in to help that participant get over the finish line and have all their finalized documents and things like that. But we do ask that between that 9 to 3 time period, you don't schedule other meetings or other client calls, things like that. You will not be working every single minute of that 9 to 3. So you are, of course, welcome to do work on your own when you are not directly working with the client, or like if you're waiting for them to respond to you, things like that. But please be generally available for that whole time period, because there's no way of knowing exactly how long you're going to need to be working with that client. So there are 2 shifts, essentially. You will not necessarily know which shift you're getting until you receive an email from the pro bono project coordinators letting you know who you're going to be assigned to. So even if you're going to be on the second shift, that's why we still ask that you don't make appointments or things like that in the 9 to 10 timeframe. So we have 4 clinic participants per clinic, generally speaking. 2 of them are at the 9:30 shift and 2 of them are at the 10:30 shift. So before each shift, and that's when they expect to be called, roughly, we ask that you show up 15 minutes before that for an introduction meeting with myself or Priscilla. We'll walk you through the plan for the day, the logistics, answer any questions, and give you some information about the clients who you will be working with. So it's really important that you are timely for that meeting, and that you are able to then coordinate with your coworkers who will be on the team with you to reach out to the client. Because this is fully a virtual clinic, you will generally be speaking with clients on the phone. Some clients do prefer a Zoom meeting, and so we can definitely arrange that. But generally, it'll be you and your coworkers conference calling the clients. So the first shift, that 9:15 to 9:30 intro meeting, and then there's at 9:30 or whenever we wrap that up, they are set free to go and call their clients and start working. And then the second team shows up at 10:15 with the anticipation of calling their clients at 10:30. So after meeting with myself or Priscilla, you guys call the participant, you introduce yourselves, you explain a little bit about the process, and you can begin actually drafting the documents. And that'll be later on in the presentation. What are the actual documents that you are expected to be producing? You can expect to be making multiple phone calls over the course of the day. And this is part of why, you need to be available for that whole time chunk. Is there's no way of knowing upfront, like how many phone calls exactly, how long those phone calls are going to take. Generally, I think it's safe to say anywhere from like 2 to 5 phone calls spanning over a number of hours is most likely, because you will need to be drafting documents with them. And then if the participant is choosing to file that day, there will also need to be phone calls at the end of the day to review the documents and to then help them to file them. And to do the just kind of summarizing at the end of it all to make sure that the client understands what their next steps need to be. And like I said, if 3 o'clock rolls around and you are not at that stage of actually wrapping up with the client, that is totally fine. We can step in, provide any support that is needed. If you are able to stay past 3 and you want to see that participant through to the end, you are more than welcome to, certainly. We're not going to like kick you out at 3 o'clock, but there is no expectation that you are burning the midnight oil on these. We and the FJCs who the clients are actually connected to are perfectly able to step in and help provide that last bit of support. During the whole day, the supervising attorney will be available in the same Zoom room that you come into for your initial intro meeting. So you are always welcome to pop back in, ask any questions that you have. Oftentimes, we will review documents together, like if you send a document for edits, and it's easiest just to review it together over the Zoom. That is not uncommon. So we are available to you for the whole day. And if you prefer email or even other ways of contacting that you've established with your supervising attorney, that is also definitely fine. But the Zoom room is a surefire way to get to speak with your supervising attorney. You might have to, if there's multiple fires happening at once, you might have to have a little bit of patience, but we will absolutely get to your questions. At some time during the day, the pro bono attorneys, you guys, will be sending drafts of all of the documents that you're working on to the supervising attorney, and then those drafts will be edited and then finalized to give to the client or to be filing. And then the supervising attorney, once they give the go for finalizing those documents, you can start on that filing process with them. So what are the actual goals? What are we hoping that the participants get out of this clinic, right? Because I know what I get out of it, and I like to think I know what you guys get out of it. But really the people who we're here for are the participants. So teams working with any given client can expect that if they are filing any kind of a support case, so that could be child, spousal, or child and spousal in one petition, that there will be an initial petition that you draft, and there will be a financial disclosure affidavit. If it is just a paternity case, the only guaranteed document is that initial petition. So the initial petition is the actual document that starts a case. It is where you provide information to the court about who you are, who this other person is, and what you're asking the court to do. The financial disclosure affidavit is a very important part of any support cases because it's a document where each party has to present their own, but you are giving a full picture of your finances, your income, your expenses, your loans, your debts, what's going on in your life, so that the judge can plug all of those numbers into the necessary equations and get the actual child support amount at the end of it all. And the financial disclosure affidavit is not something that you are going to be filing with the clients. That is just something that they will receive at the end of the day, and then they will present to the judge when they actually end up in front of them, which could be, unfortunately these days, about 7 months after they are filing. So it's this sort of document that could also definitely change in that time period. But even if they have to redo it closer to that date because their financial situation changes, you have given them such a step up from where they were because they've already done it once. They've already thought through a lot of these questions, and they were in a much better position to be able to present the updated information on their own than they would have been if they were just starting from scratch without anyone else. And then there are a couple of documents that may be needed in specific situations. So there is an address confidentiality request that can be filled out. If folks don't want their actual address to be listed on court documents because they have safety concerns and they don't want the respondent to know where they are residing, or if they are in a shelter, especially a domestic violence related shelter, and that address should be kept confidential anyways, then they can request that the court just does not list their information on the summons and on any other court documents, and instead lists the clerk of the court as essentially the proper person to be serving any papers on. And this, if they're already enrolled in the New York State Address Confidentiality Program, they don't need to also do this, but most folks are not aware of that program, unfortunately. And then there's also a personal information form that is necessary if you are filing in a county that is currently using the NYSIF filing system. And you will know that by the time you are filing. There are filing instructions available on the Pro Bono portal, which we will get into. And that's always something that the supervising attorneys can help you fill out as well. So filing wise, all petitions are going to be filed unless the client has decided to hold off on filing. There's any number of reasons why someone might not be prepared to move forward with filing right now. And that is perfectly acceptable. Just like with the financial disclosure affidavit, having a petition that is finished and ready to file in hand can make a huge difference to these clients, because then whenever they are ready, they can just go file it. Those sorts of things don't expire. Maybe they have to re-sign or redate it, sorts of things. But you are doing, an enormous amount of work for these folks who otherwise would have to do it completely on their own. And so we definitely think of it as a win, even if they don't end up filing that day, if they have a better understanding of the process that lies ahead of them, and they have these sorts of documents in hand. And like I said, the financial disclosure affidavit will not be filed, but you will be giving the client the finished PDF version at the end of the day so that it's just ready whenever they are going to be handing it in. And then the last component of what's expected of you is to advise the clients. So that's part of why you get this basic training on the support in the paternity substantive law. We intend for this presentation and the PowerPoint that you will receive to be a bit of a manual of sorts. This is absolutely a resource that you can look back on during your actual clinic day if you feel like the client has a question and you're not sure what the answer is, but you think it's contained in here. You can also just come and ask us at any time. That's why we're available to you. But you will be expected to do a certain amount of discussing with the client on the basics of the litigation process. So what it will look like to file if they're going to be filing themselves or with you, how service and return of process work, And then the fact that they are going to eventually have a hearing or a settlement that happens and the final child support order that is entered. So we don't expect certainly that you are walking them through every single step of the process and what they can expect, but giving a general overview of what is coming down the pipeline for them, especially for folks who are not going to have an attorney with them, can be helpful for them to imagine and kind of project into the future what they are going to be, responsible for, and that can inform whether or not they're choosing to file at this time or not, if they have that sort of capacity. And then just reminding them about how the FDA is going to work, and that that is going to be on them to provide their own information. The opposing party has to provide their information separately. So this sort of document is just on the participants' financial information. And then discuss service and summons with them. We have information for you on that in the checklist and some other documents that are all in the pro bono portal again, that you can review. But generally speaking, you will need to tell them that they, as the petitioner, are going to have to serve the respondent, not themselves, because it has to be someone other than a party in the case who's over the age of 18. And not on Sundays, which is just a weird little tidbit, but they can coordinate with their local sheriff or a process server or just a friend or family member. But they are ultimately going to be responsible for effectuating that service. And then making sure that they have Sanctuary's contact information in case they have any follow-up questions, and they know who to reach out to receive any further services. And then suddenly you blink and it is 3 o'clock and the clinic day is over. So by the end of it all, the hope is that all of the petitions have been completed, signed, and e-filed if the client is ready to be filing today, that the FDAs are completed and provided to the client, and that the clients receive from you in an email any documents that you drafted, the child spousal support manual that it contains a lot of very important information for them, and any documents providing guidance for the next steps, including the checklist, or potentially, a summary of what you guys talked about, those sorts of things. And then we ask that you send us any information on what sorts of questions they had that were unrelated to child support. So it might be that in the course of talking with the client, they mentioned that they have custody needs or an order of protection question. We certainly do not expect that you guys are able to advise on those sorts of things, but we just need a heads up from you if that came up in your discussions at all, so that we can do the follow-up necessary with the client on our end. So some frequently asked questions. What if the client does not answer my call? So the clients should respond. They are aware of the clinic date. They have multiple conversations leading up to the clinic date with various Sanctuary staff members who confirm their participation, but that doesn't guarantee that they will actually be available. Our clients have a lot of very complicating factors in their lives. There's a great number of reasons why someone might be suddenly unavailable. And so it does happen that when you reach out to the client, they are no longer available, or they might not want to answer if they don't recognize the number. As a millennial, I firmly support not picking up if I don't recognize the number. So I totally understand if that's what our clients are experiencing. So we would just ask that you leave a voicemail, shoot them a text, let them know who you are and why you're calling, and then pop back into the Zoom room and just let us know that you had this difficulty. Generally, I would say, what happens is we give them a bit of time to respond. If say 10, 15 minutes passes by, maybe send another text. But if the client is simply no longer able to participate or never responds, then and if you are, super jazzed and you're like, I've got to do something today, it's possible that we can attach you to another team that is already working with another client, or you will just have the rest of the day to do your own work things. And we appreciate your availability and hope that you return for another clinic where hopefully you will get more of that hands-on work. What if the client asks for advice on something else that you are not working with them on at that exact moment? So I pretty much already went through this, but you don't need to give them any of that advice. Just refer them back to us and make sure that they know who they should be reaching out to get that further support. How long should the calls be? It's really hard to predict. It depends on how much information the clients are coming into the conversation already knowing, especially with things like finances, how much inquiry you have to do. If you're able to really dig deep into the questions that need to be asked on the first go, maybe it takes a little bit less time. Maybe folks need a bit more of a walkthrough of their safety concerns or any other questions they have. So the actual drafting itself might not take terribly long. It might take you longer than you expect, because if this is your first time looking at any of these petitions, that can be a little bit daunting. But if you end up being a repeat volunteer, which we actually have, I'm very excited to say, a number of folks who have been in 2 or 3 clinics with us. Each time you get a little bit faster, a little bit more efficient at the actual drafting, and can focus more of your attention on the conversations that you're having with the client. And then this is information on the pro bono portal. Pro bono portal is like combination Rosetta Stone, Bible, like best book you've ever read. It is the place where all of the information lives. So you will, when your actual clinic date is upcoming, you'll coordinate with our pro bono team to get access to the pro bono portal. So we just ask that you have made that request and gone through whatever the process is that your firm has set up before the actual clinic date, because since there's so much information in the portal, it is always fantastic if folks take a little initiative and dig through it a bit to see where the information lies and if there's anything that they should be reviewing ahead of time. But even if you're not doing that, just knowing that you have access to the portal on the day of the clinic is important, because that's where the templates live. No one is asking you to reinvent the wheel on these petitions. We have templates for everything, but the pro bono portal is where you access all of those. And then after you log into the portal, the way to find the actual project is to search under the resources tab for Pro Se, and we are the Pro Se Child/Spousal Support Petition Drafting Clinic. Ooh, that's always a mouthful. To find our actual project page and then all the documents from in there. So this is also a tech issue that if you're having any issues navigating the portal, pop over and just ask us. Okay. Any questions on clinic logistics before I move on? Cool. Well, then we can get into the substantive law portion of things. So this is just a bit about child and spousal support. So these are governed by Article 4 of the Family Court Act, and there is a statutory duty for parents to support their children until the age of 21. And so if you are the custodial parent of a child under the age of 21, you can file for assistance. And custodial parent doesn't necessarily mean they have a custody order. It really just means the parent who the children are with the majority of the time. That is the person who is generally considered to be eligible to be receiving child support. And then the assistance goes back to the date of filing. And what I mean by that is, say I file tomorrow for child support, and then in 7 months, I'm in front of the judge for the first time, and I receive a temporary order of support. That money, I'm not going to be seeing any of it until I'm actually in front of the judge and that order has been effectuated. But the order will be backdated, essentially, like retrofitted to my date of filing. And so now the respondent is going to owe me that temporary support amount moving forward, but is also going to owe me for those 7 months. So that's really important for folks, because even if they are not able to get that cash in hand for a longer time than would be ideal, they are still going to be getting that money. And so the sooner they file, the more money they will be getting, essentially. Child support is handled in the family court by support magistrates. So that's slightly different from a judge or a referee. They are specific to child support matters. And parties are not given, we call them 18Bs. These are free court-appointed attorneys that are available in most family court cases. Parties are not guaranteed that in a child support matter unless a party is risking incarceration. So if you are trying to allege that someone has willfully violated an order of support and they owe you a ton of money that they're just not paying, there's the possibility of incarceration. But outside of that, just in a standard child support case, folks are going pro se generally. You file a child support case in the family court where you live. Technically, it could also be where the respondent lives, but for convenience sake, because we care about our participants' convenience much more so than the respondents, generally folks are filing in the county where they reside. The one reason why you might want to file where the opposing party lives is if the respondent doesn't know what county the participant is currently living in. Maybe they are trying to stay quiet about their location, or they are in a domestic violence shelter, and you're going to be filing that confidentiality, the address confidentiality anyways, then that would be a reason to file in a borough other than where the client lives. But that would be something that you discuss with the client. So then the actual calculations. So, part of why the courts say you don't get a free attorney in child support matters generally is that it is truly math. There's a big difference between the sort of subjective arguments that are being made in something like a custody or a family offense case and the just numbers arguments that happen in a child support case. So what generally happens is both parties supply all of their financial information to the judge. The judge plugs in all of that information into this calculation. And so they're looking at what is the total pot of money that these children would have had access to had these parents been able to stay together, and what portion of that pot of money are each parent now responsible for. So if you are the custodial parent, if you have your kids with you, you're more likely to be the one who is paying for lunch money, for field trip money, for the clothes, those day-to-day sort of expenses. You have a much heavier burden of providing. And so the non-custodial parent is expected to pay a higher percentage of the total amount of money that the children would generally have access to make up for that, and to then be providing for the children. And so this duty is actually between the child and the parent. It is not parent to parent. So that is why that for child support specifically, it is about how this parent is providing financially for their child. Spousal support is a little bit different because that there are additional factors that go into those calculations, including the length of the marriage, and more about like the qualifications and the income and the ability for this person to become independent. Child support is not based on, timing or things like that. You had a child, and so you are financially responsible for them. So the first steps is that the court calculates the adjusted gross income. So that is that pot of money minus taxes, Medicaid, Social Security, any of those sorts of things. Then they add them together, find the ratio, and then multiply it by one of these percentages, depending on the number of children. And so then, as you see, it starts at 17%, goes up to 35%, caps out at 4 or more children then, 5 or more children. And then the number that it spits out is that default number. There are reasons why there might need to be changes to the default, or why there might need to be additional, like you have your default, but then you say there's an additional expense that needs to be calculated separately. Say for a medically complex child who has really high medical bills, that custodial parent would be receiving that default payment and potentially an additional payment specifically for that issue. But for the most part, that default is what's going to be working. You can help your participant to calculate what they can expect from that default amount. We use what's called the Joy Rosenthal calculator, links up here. These screenshots are essentially the beginning and the end of the calculator. There's a lot of stuff in between that you don't really have to pay attention to unless there are, the client is telling you that there is a bunch of additional information that is needed, such as the respondent pays child support to other children in a different family sort of deal. But for the most part, you will just be inputting the incomes here and giving basic information on, the taxes and things like that. It'll calculate the taxes for you. And then this summary at the end actually lays out what is expected. And if you put in the information for both child and spousal support, also called here maintenance, then it'll give you the amount that you can expect for the money. And for maintenance, it'll also tell you how long you can expect to receive it, based again on how long you were married, and some other factors. And then it'll even tell you how much you can expect from each of those if the other one gets terminated. So that's really only applicable for folks who are filing for child and spousal support. But like I said, you might have folks who are doing one or both in the same petition. So going through this calculator at some point in the day, there's not a particular point where it makes the most sense necessarily and across the board. But at some point during the day, going through this calculation with your client can really help them to understand and plan for their future once they know, like, this is about as much money as I am expecting to receive. That number might change depending on what information the respondent provides about their own finances. Maybe it's considerably less or more than what you calculated based on what the client originally thought, but this gives them a ballpark at least. So here's some complexities that can arise with child support cases. So folks will come to us and say, this person is a freelance. This person works, under the table. I don't actually know what they're doing anymore. And so when someone doesn't have a very confident source of information for the respondent's finances, it can be difficult to calculate what that income is going to be and how they are going to be able to either help prove or disprove what the respondent is saying, because it absolutely can be an argument that if you believe that the respondent has lowballed essentially their income, and that they had multiple jobs that they were not providing that financial information on, you being the client can present information to the court showing that this person is not being truthful. But not everyone has access to their respondents' bank accounts, credit card statements, things like that. But it is a possibility, and it's something that you may need to be talking your clients through what their options are there. Like I said before, add-ons can be ordered. So there's mandatory add-ons for things like contributing to childcare if the custodial parent is going to school or is working, unreimbursed medical expenses. And then there can even be things like educational expenses if the children are going to specialized schools or having to pay tuition for those sorts of things. Those add-ons are in addition to that default amount. And because the actual duty is between the child and the parent, child support can't really be waived, even in a divorce context where you haven't had a child support case that has actually been litigated. There is a statutory minimum that the non-custodial parent is paying $25 per month. And that is also true if the non-custodial parent is engaged with certain public assistance or supplemental security income programs. That $25 a month is the absolute minimum that someone will be expected to pay, but it is still something. And then when a custodial parent is receiving certain public assistance, so things like cash assistance, rental assistance, really any program where they're being handed cash directly. So things like SNAP or WIC are not a part of this. If you have those, then you're perfectly fine. But if you have cash assistance or rental assistance, you actually assign your right to collect child support to HRA, who is the agency that manages those assistance programs. And so your client can't file for child support in the family court while receiving those. The proper thing to do would be that HRA files that support claim and then is the recipient of the money. But unfortunately, you cannot receive both cash assistance and the full amount of child support at the same time. You have to pick one or the other. And so we screen for that. That is part of our eligibility process. When way back in the beginning of this, when I was explaining the actual screening attorney role, they are supposed to be discussing all of this with the client at that stage. So it shouldn't be that by the time the client is getting to you, they still have questions about that. But if they do, then that's absolutely something that we can help with, and we can even hop on a call with the client and explain what their options are if they manage to, slip through the cracks. When it comes to actually collecting child support, in New York, we have the Support Collections Unit. And for the vast majority of our clients, the SCU is necessary. In theory, folks can have a child support order where one person is directly paying the other person. However, due to the nature of the power and control dynamics in many of the relationships that we see and the violence that has occurred. We don't want folks to have that kind of access to the clients anymore. And so the assistance of the support collections unit is requested. And so SCU can directly go into folks' accounts. They can garnish their income. They can take money out of tax returns. If you get workman's comp, they have their fingers can really dig much deeper than anyone just as a layperson can to get that money, and they are then responsible for getting it to your client. So the client never has to worry about hunting this person down and trying to get the money that's owed to them. For spousal support, it is pretty much the same. You'll see the petitions look very similar. They are heard by the same support magistrates. However, for spousal support, it is only available to folks who are legally married during their marriage. So you might see this called spousal support, maintenance, or alimony. We use different terms depending on where in the process essentially it's happening, whether it's during this sort of a, you're still married time period, or if it's happening after the marriage as part of the divorce, but they all mean essentially the same thing. And it is mandatory for the family court to give the guideline amount of spousal support to the lower earning spouse. But if there are arguments that that amount is unjust or inappropriate, then they can deviate. Spousal support orders are also non-durational, which means that just like with the child support, the assistance goes back to the date of filing. But what can happen is someone receives a temporary order of spousal support while the case is pending. And then by the time the case wraps up, the magistrate says, you've already gotten the amount of money that you were going to get out of this process, so I'm not going to order any further support. And so then that can be a point where that order is ended, or so when that divorce is granted, essentially, or if the Supreme Court, which is the court where divorces happen, modifies that spousal support order during the pendency of a divorce action. And once again, parties are not given free attorneys for this sort of a case. Spousal support is highly dependent on income. And so if the spouse's incomes are too close together, even if there is still one person is making more and one person is making less, the lower earning spouse might not be eligible for spousal support because of the way that the calculations work. It just might not, or if they were not married for a terribly long amount of time, they still might end up not getting any money. And there is a number of deviation factors of why they might find that this is an unjust or inappropriate amount. And so those can include things like the age and the health of the parties, both parties' earning capacities, a history of violence, how the standard of living was during a marriage. If one person who was the primary breadwinner was given, really lavish lifestyle to the other person, there's no expectation that suddenly the lower earning spouse is going to be having a completely different lifestyle. They will not be provided for forever, but they will be given money to live the way that they have expected to live, and the way that when they entered into the marriage, they thought they were going to have for the rest of their life, for a period of time that's appropriate for them to get their feet back under them and to live independently again. And then there's any number of other factors. If you're curious, you can look at the Family Court Act, Section 412. So this is how it's calculated. This is all math. And, in the spirit of full honesty, I became a lawyer to not do math ever again. So I completely understand if this is just kind of daunting for you. You don't actually have to do any of this math, though. And we don't expect that you are explaining this to the client in super detail, but just being able to speak kind of broadly about the way that the calculations are used is very helpful for the clients. So there are two different formulas depending on whether or not there's going to be a child support payment as well or not. And it's the same income, the adjusted gross income that you're using for the child support. It's just a slightly different, the numbers are going to be different. So you multiply each of their incomes by a certain amount, subtract the payee from the payor, do a 40% of combined income subtraction, and then whichever one of those is lower, then that's going to be what you're entering. And so then there's also an income cap of $184,000 plus payee's income. And so again, you do not have to actually do this math. You don't have to know this math. That's what the calculator is for. But using that calculator with a little bit of insider knowledge can make it a much smoother process. So timeline of a support proceeding, the first you're filing, then you're doing the service of process, which, like we talked about, is the petitioner's responsibility. That can only actually happen once the filing has been processed. So you can explain to your participants that once you file, they can expect in a month, maybe two, to receive emails from the court where they will receive documents that discuss what service has to look like, as well as some more information about the court process and the summons to appear. So that document will have the actual date and time of their first court appearance, the judge is going to be in front of. And so you can't effectuate service until you have those papers, because that is part of what you have to serve on the respondent. But as soon as they get that email, they can arrange to have all of the documents that are necessary sent to the respondent, given to the respondent. Personal service is required, at least attempts on it at first. And then after that happens, your first appearance is going to be a return of process, where if you have managed to serve the respondent, then the judge, either they will show up or they won't. And the judge will choose if the case is going to move forward or if additional service attempts are needed. And yeah, right now we're seeing about 7 months between initial filing and first appearance. So if your client, if you explain that and they're like, well, what am I supposed to do in the meantime? That is the sort of benefits related question that their FJC case managers or sanctuaries benefits folks can help them to figure out how to get through that time period. And then once they're actually in court and working with this magistrate, there will be a fact finding, there will be opportunities for objections and potential deviations from the order. And then at the end of all of it, they get their final order of support. They can have a temporary order of support that throughout while the case is pending, but the final order of support will be the one that is actually in effect given to the SCU for the duration until the child or children are all 21 and can be modified in the future as well. But it is a long-standing order in that kind of way. So at that first appearance date, everyone has to show up, assuming that service was effectuated properly, so that they can give a number of documents to the judge and also pick future dates. So at this point, they will be giving over their financial disclosure affidavits. The client can, at this point or as part of the next appearances, give over things like pay stubs, tax returns, documentation of childcare or expenses, if they're requesting certain add-ons, all about their own finances, because the other side is expected to provide their own financial information. But again, like we said before, if there is concern that the other person is not telling the truth, then the petitioner can provide proof of why they believe that that income should be different. And that income can actually then be imputed by the judge. And so the judge will say, I see on your paperwork that it says you make $40,000 a year, but I have a very credible reason to believe you actually make $60,000. So I'm going to put $60,000 into that calculation instead. And that's something that judges just have the discretion to do. And so if you're able to, as a participant or as a petitioner, have that happen, you will stand to gain quite a lot of money potentially. Right. And then that brings us into paternity. So why might you need to file a paternity case? If you are the custodial parent, but you don't have the custody orders, things like that, you are just the parent who has the children, and you want to receive child support, but there has never been a formal acknowledgement of paternity. So you might have someone who is the biological father of your child. Maybe they even, informally acknowledge that they are the father of this child, but they never signed a birth certificate. There was never a previous paternity case. No formal acknowledgement of paternity exists. You need to, in order to receive that child support, prove first that this person is the person who should owe that child support, who has that duty to this child. And so the first thing that you may need to do before actually filing for child support is to file a paternity case, alleging that, this is a person who you believe is the father of this child, and this is the time window where sexual intercourse was happening that makes you believe that that is the person who is the father of this child. And so you just need to establish that. Another reason might be, and this is one that we actually see frequently because we have what's called the Uncontested Divorce Project at Sanctuary. And so this is one where we get direct referrals specifically for this situation, is that if you are married to one person and during that course of the marriage, you have a child or children with someone outside of that marriage, and now you're trying to get a divorce from your spouse. There is a marital presumption when you have a child within a marriage that the person who you're married to is the legal father of that child. So in order to get the divorce, that the spouse, who is not the biological parent, has to be able to show the court that they are not responsible for this child of the marriage, essentially. And so in these situations, it's actually interesting because instead of just one respondent, both the spouse and the purported parent are respondents in the case. And so that gets a little bit more complex, but it is still essentially the same template. You are just adding in information about two respondents instead of one. And then ultimately the paternity is established. Only one person is going to be the legal father at that point, and then the divorce can proceed, or child support for that now legal parent can also proceed. Another reason why a paternity case might be needed is if the non-custodial parent wants visitation or even custody, but there's no acknowledgement of paternity. Because in order to start either a custody or visitation case, you have to be able to say why you have the grounds to have custody over this child. And so that's going to have to be because you are the parent generally. And so if there is no legal acknowledgement that you are this person's parent, then you need to establish that before you can establish a right to this visitation. So what can happen in a paternity case? Sometimes things get resolved on consent. You can have a very brief hearing in front of the judge with just a couple of questions about which are essentially already answered in the petition for the most part. So at the time of conception, were these people having sexual relations that could have resulted in the conception? Was there anyone else who could have been the biological father at the time of conception? Has anyone else ever been adjudicated as the father through a court process? Has there ever been any other last name? These are all sorts of questions that just get to the heart of, is this person the right person to have this responsibility to this child? And then if there isn't a consent, so the respondent is saying, I don't think I am the parent here, or I don't want to acknowledge that I'm the parent, then there will be DNA tests, and then that outcome will be determinative of the paternity. There's not really any way to get around that. So this is what a paternity petition can look like. You'll also see this. So this is like the court generated form. Our forms look very similar, but just a little bit nicer. So please always make sure you are using the templates that you find in the pro bono portal, because all of these sorts of forms are available on the court's websites, but we have special, nice templates for you to be using. So there should really never be any reason why you're going onto the court's websites and taking the forms directly from there. But as you see, it lists some basic information about where they're residing, what that window of sexual relations was like, some information on the children themselves, and then the notices to the parties. So they're very bare bones. I would say that these sorts of petitions are probably the quickest ones to get through, and there may be some additional digging that needs to be done if essentially the math doesn't math, as far as like if the participant is telling you that they had sexual relations with this person for a certain time frame that doesn't match up with the birth of the child, essentially, and then the conception or the gestation window. You might have to go in and have a second conversation with them on that, but generally speaking, this is a pretty quick, bare bones sort of deal. And so basis for requesting paternity, name and address of the parties, names and date of birth of the children. Has there been any prior applications for paternity? Is this child subject to ICWA, which is the Indian Child Welfare Act? That's just a very particular, very niche situation. If that does arise, then please let us know. But generally speaking, that's not going to be something that you have to deal with. And then all this mandatory language, and that's it. They sign at the end. So then what does a child or spousal support petition look like? This one is just a child support one. So you are, again, very similar information. Where do you reside? Who is involved in this case? Who are you actually responsible for? Why do you think that this person is responsible? Was there an acknowledgement of paternity? Are they involved in are they on the actual birth certificates of the children? Or has there been some sort of a paternity agreement that has been made? Usually it's birth certificate, but it could be, any of these sorts of things are possible. And then, again, similar information on why you are requesting this relief and what you are actually requesting. You are requesting that child support services and you are requesting the actual support. This is something that you should be attaching a copy of a birth certificate or whatever the acknowledgement of paternity is, things like that, because it has already been established. Most of the documents that the participants are going to be handing over to the court, they will be doing on their own. But attaching a birth certificate or marriage certificate here is going to be very helpful to them and can be done at this early stage. One major difference in the support petitions from the paternity petitions is a basis for respondent income section. So that's where you can say whatever businesses or employment the participant believes respondent is currently engaged in, because that will be a signal to the judge. If when everyone is providing their financial information, the respondent doesn't include those businesses or those employments, then that's something that might require some more digging, some more follow-up to figure out what's going on there. And if the participant doesn't put that sort of information here, the judge will have no idea about what's going on there. So that's really it. They can be pretty straightforward. The support ones can take a little bit longer than the paternity ones just to make sure that all the information is totally correct, but they're pretty straightforward. And then a spousal support petition is almost identical. It's just if there are no children involved, and there won't be any children listed, and you would be including the spouse under the part of the people who you are charged with supporting. But then everything else pretty much is the same. And you wouldn't be attaching a birth certificate, of course. You would just be attaching that copy of the marriage certificate. Again, all the same at this point. And then sometimes you have both. And so if you have child and spousal support requests that you're making, they do not need to be two different petitions. It can all be just in the one same petition. And you just make sure that the heading, like the caption on the upper right-hand side, shows very clearly that you are requesting both child and spousal support. And that'll all just be one case for them. And then when you're doing your calculations on the Joy Rosenthal calculator, you just want to make sure that you're including the box that you have to check that says make it child support and spousal support. So when it comes to talking about the confidential address situation, this is something that you should discuss with all of your clients. Not all clients are going to have safety concerns that require them to go through this, though. If they do, you should not include their address on the actual petition. You can just put in big letters confidential, where the line of petitioner resides at. You just don't put it there. And then they will eventually need to provide the address to the clerk of the court. That will be kept on file, but that can be a PO box. That there just needs to be a way that the court can still communicate with them. And then in the future, either on this case or on any modifications or violations that get filed, service of process from respondent to petitioner will be a lot easier for the respondent. And it's possible that the petitioner will get kind of left out of the loop on these sorts of things, because when you're saying my address is confidential and you assign the clerk of the court as the person to receive your documents for service purposes, it's kind of a two-way street, because you are having your safety concerns met, your address is being kept confidential, but you may have to work a bit harder to make sure that you're getting the documents that you can be expecting. And because if summons are issued on matters that they are not aware of, and then they don't make their appearances, things could be entered against them in a default way, even if they were not aware of what's going on, because technically service was effectuated properly. So what are the required attachments on any of these petitions? So for the child support, you will want that documentation of the parentage. Spousal support is the marriage certificate. And for paternity, if they have the birth certificates of the children that show that there is no father named, then that is important to put in as well. If they have birth certificates where a different person is listed as the father, that's something to flag and ask us about. So what does it look like to draft a financial disclosure affidavit? To be honest, this is the part that tends to take the longest amount of time, because you are really digging into this with the clients, and they might feel very sensitive about some of this information, or they might just not be coming from a super knowledgeable place, right? If we have folks who are coming out of situations where their abuser was controlling the finances, they might not know what a lot of their expenses are, because they were never given that sort of agency. And so it can be hard for them to, come up with what's going on. So trying to help them to either jog their memory or to create estimates, thinking about what in the course of a month, how much do you spend on clothes? How often are you going shopping? What kinds of meals are you eating? To think about food expenses, things like that might be required. And then the attachments that they will eventually need to give, because remember, we're not submitting this, we're not filing it on the date of the clinic, are things like tax returns, W-2s, and pay stubs. And these are supposed to be a temporary snapshot of the client's financial situation. So that's why it's also important that it is updated when they are actually going in front of the judge, because the judge doesn't want to know what was happening 7 months ago. They want to know what's happening right now as this snapshot. So you'll go over the income and expenses together. Recommend that you list out the expenses first and then talk about income, because that tends to be a bit easier for folks to get through it that way. If you start with the income and then you're trying to work backwards, essentially, sometimes the math gets a bit funky. And it's really important that at the end of it all, the income and the expenses are pretty close. Ideally, you would have a higher income than expenses. Our clients are often very low income, and so if they are living, either paycheck to paycheck, or they are taking out a lot of loans or credit card debt in order to pay for their expenses, and so that is showing a much higher expenses than income, that is something that they will have to explain to the judge, and so you can speak with them a bit about how to communicate to the court about those sorts of things. But it is going to be a red flag for the judge if they're given a piece of paper where those amounts are just wildly different. So you may have to do some follow-up and some further digging with folks to figure out why that discrepancy is happening. If it's just a matter of maybe over-exaggerating the expenses or under-appreciating the income, or if that is an accurate reflection of what is going on in this person's financial world. And then here's what the FDAs generally look like. So as you can see, it starts off by asking about the income that the person is receiving. It wants to know about the health insurance coverage for them and the children, and then assets that they might have, and then all of their expenses. This will be in the portal. You'll see it is a PDF that is editable. So please do not convert this into a Word document. It will mess up the formatting so bad. There is never going to be a way to get it back into the PDF way. And so you should just be able to edit as long as you have Adobe, and you can also then add in. So if there is an expense that you think doesn't fall into any of these categories, you can do like a little text box right underneath and just do like an asterisk and put in that information. So it should be fully editable. If you have issues editing the document, let us know and we can try to troubleshoot that with you. But just, please don't take matters like into your own hands and be like, oh, I can convert it, or let me find a financial disclosure affidavit on the court's websites. This is the version we would like you to use. And so if you have issues with it, then that's absolutely what we're here to help with. But it should work as well as possible for you. So yeah, so this is just more details on what is actually included in here. Income from all sources is important. And if they say that their pay is erratic, or maybe they don't have a stable paycheck where they're getting the same amount every time, you can take the yearly average and just divide it by 12 to get a rough monthly approximation, or even a smaller chunk of time. So at least 3 months we would recommend. But this includes self-employment and any other income as well. All of the insurance information, childcare providers, especially if they are going to be requesting a childcare add-on, that sort of information and the accurate amount of money that they're spending on it is very important. And then all assets that they have, if they have accounts even in other places in the world, that should all be included. And then the expenses part, this tends to be where folks struggle. Which is another reason to start to do that before you get into the income part, because if you're going to be taking the most amount of time with this, you want to make sure you have the time to do a really thorough job. So it doesn't need to be exact. They don't need to be able to produce receipts or things like that, but it should be approximate. So even if you're trying to do an average over the course of a couple of months, then that's fine, but you are still putting the monthly amount in there. So you might just have to do some math if they think like, well, I spend this much in 6 months, you have to sort of back it up to that 1 month time frame, because you want to make sure that all of the expenses that you're putting are for the same time frame. And so there might be additional areas of costs, like other things for the children, like formula and diapers. Like I said, you can just kind of add that in at the bottom here. And then they don't actually need to sign or have this notarized right now because it's not going to be filed. So whatever final version of this they're going to be submitting should be signed and notarized, but you don't need to worry about that for this one. And this is us. So this is my information, Priscilla's information. Those are going to be probably the 2 people who you hit up if you need anything. Lindsay and Priscilla's supervisor, Alette, are generally available, especially on clinic days. They really do come in clutch on that support. But they are not the primary folks who are running the clinic. And then, so that's Priscilla and I. And then the folks from the Pro Bono Project, who are Nicole and AB, I think AB is on here, so please just wiggle a little bit. So folks can know who you are. They're who you will be receiving most of the communications leading up to the clinic from. So you'll be receiving the emails on what time you're assigned, who your participant is going to be, any documents that we're able to pass along to you. That's going to be coming from AB. And then if you have general questions or you're not sure who exactly to contact, we have, all of us are on the same email, which is down below here. The FJC Petition Clinic at sffny.org email goes to all of us. So if you have any questions, that is always a safe way to get a hold of us. And that's really it. So at this point, if we have any questions that folks have been dying to ask or things that you need any further information on, feel free to just, you don't even have to go off camera. You can just raise your hand and I'll call on you. All right. Well, you're always welcome to hit us up with questions later on, but I'm not going to make you sit here for 17 minutes if there aren't any further questions. Thank you so much for joining us for this presentation. And this recording will be available in the future if you need it. And if you have any friends or colleagues who you're like, I think that they would be a really good fit for this, or maybe they would enjoy it, please feel free to pass it along to them as well. And then they can get looped into the Sanctuary volunteer family.
Great. Thank you all so much. I'll also just put our email in the chat if anyone wants to follow up with email questions. Hope to see you.
Thank you.
Thank you all.
Thank you.